I will call this meeting. It's 6:30. I'll call this meeting to order, and let's start with the pledge of allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, everyone.
Okay.
If we can, I know our clerk better is on Zoom. If you would like to do roll call for us.
Thank you, Madam Mayor. Mayor Smith,
Here.
Mayor Pro Tem Valentine,
Here.
Trustee Shelter,
Here.
Trustee Schwartz, Trustee Check,
Here. Oh, that was chat. Just join.
Trustee Hunter,
Here.
Trustee Heck.
Here.
You have a quorum.
Thank you. Did Trustee Schwartz join? Oh, okay, good. Oh, very good. Now I see her. Great. The next part of the agenda is the approval of the agenda, and I had two requests of the trustees about modifying the agenda. And the first is that we have been asked by the two entities that are legacy events, if we would remove action item number 3, consideration of creating a legacy event designation, if we would remove it from this agenda and continue it to another meeting. So that's one change I wanted to bring up to you all. And secondly, we have an executive session scheduled for the end of the agenda. And we have one trustee that cannot stay past 9:30 and another that may not be able to participate for the entire meeting. Therefore, I'd like to ask you all to move the executive session up to after action item number 2. Yeah, that would work. Action item number 2, so we will have action item number 1, the STR rentals. We'll go ahead and do action item number 2, which I don't think would take much time, and then the executive session, and then when we get back, continue where we are. But I want to say that I may, in the middle of the meeting, ask, when we get back from the executive session, depending on timing, I may ask that we change the agenda at that time. But we'll see how time permits. So if that makes any sense, and somebody would be willing to distill what I just said into a motion, that would be wonderful.
I would like to make a motion that we move the executive, first of all, that we move the action item of the legacy events to another meeting. And I think that should be its own motion.
Let's second that.
All in favor of that modification to the agenda?
Aye.
Any opposed? Okay, that motion passes. Thank you.
Then I'd like to move the executive session until after action item number 2.
We hear of a second?
Second.
Any discussion about that potential change? Okay, hearing none, all in favor?
Aye.
Aye.
All right, none, any opposed? Looks like not. So with that, I believe we now need a specific motion to approve the agenda. If that's correct. Okay, can we have a third motion?
I'd like to make a motion to approve the agenda as amended.
I'll second that.
All right, all in favor?
Aye.
Thank you, everyone. So we will move on to announcements, and I am going to turn that over to Clerk Better. If you're prepared. If not, I can do it.
No, I've got it. Thank you, Madam Mayor.
Sure.
So as you see, we're still seeking applications and letters of interest for our opening on the Zoning Board of Adjustment, which is why it's on here again. And we actually have 3 terms on the tree board coming up for reappointment. So We're seeking applications and letters of interest for that. And if we can have any applications and letters of interest for either vacancy by December 4th, so it can go on our first meeting in December, which is typically our last of the year. It would be nice to go into the new year with everybody knowing they're going on to committees.
Thank you. Can we add that if anyone in the public has questions, they can contact you for more information?
Absolutely. I'm more than happy to answer any questions that somebody might have.
Okay, thank you. Any other announcements from the trustees? Anybody online? Hearing none, we'll move on to the part of the agenda where anyone in the public, whether in the building with us here or on Zoom, if you have any comment you would like to make, you have 3 minutes to speak on any item that is not on our agenda tonight. So with that, would anyone in the room like to come up and speak on any topic not on the agenda? Okay, seeing none. Anyone on Zoom? See any hands, but I might not see them. Okay, no hands raised. All right, thank you. We'll then move on to the consent agenda, which consists of 2 meeting minutes, the first for our October 22nd regular meeting and the second for our November 12th regular meeting. And we also have disbursements on the consent agenda. Are there any comments from anyone, any trustees on any of the content for the consent agenda? Hearing none, nobody on Zoom? Okay, with that, can we have a motion to approve the consent agenda?
I make a motion to approve the consent agenda.
I'll second that.
Okay, all in favor?
Aye.
All right, thank you. That motion passes, and we are to staff reports with the departmental scorecard. If anyone is following on their agenda packet, the scorecard is starting on page 28.
Okay, so departmental scorecard has been updated. We just keep updating this. I don't think it's been posted to the website in some time. I'm gonna ask that it does get posted after this one, so that it's available for public consumption. Every department has updated. The one thing that you are going to, which isn't on here that you will see soon, is a new sign going up at Apple Valley Park, and a sign box.
What's the new sign?
It is about the Jumbo Mountain Trailhead.
Oh, good.
And that's a sign that was given to us by defense.
Yes.
Yeah.
Did anyone have any questions for our administrator on the scorecard? Seeing none, we'll turn it over to Police Chief Laniger for his report.
Okay. The department would like to thank Coyle Parks and Wildlife, U.S. Forest Service, and the Delta County Sheriff's Department for joining one of our officers up the park during a trunk or treat for Halloween. It was really great to see all those agencies kind of working together in one spot and talk to the community. Members of the department have completed CPR, first aid training and certification. That's an annual training for us. We do that every year. This year, the training was provided by Blake Kinzer, who's also the fire chief. We'd like to thank him for his time and his support in doing that for us. That was very helpful to have somebody come here and do that. Also, the department has changed vendors for our PD stickers. Stickers are used as a means of community outreach, are frequently given out to local schools, as well as events throughout the year. I've placed some of the stickers at the door for the public to see. The new vendor is Grit and Grace. It's a local company which is owned by a PD officer's wife. Quotes are attached for comparison purposes. The new purchasing policy was followed and the town administrator was consulted during the purchasing process. And ultimately, the change in vendors resulted in approximately 39% savings on sticker purchases. A couple things with that. One was that by switching vendors, she was able to reduce the total number of stickers we had to buy at a time. Some places wanted 500 or 1,500 of a single type of sticker. She's able to do much smaller quantities. She also designed those free of charge, no tax, no shipping. I'm being told she makes about 2 cents profit per sticker. So that was part of the reason we switched. And you also notice the quotes that are attached show some of the other costs. So the cost savings was pretty beneficial for us, but in the name of transparency, we wanted to point out that she is married to one of our patrol officers. But they did not come to us, we went to them. She's part of an organization called Operation Rehydration, where they provide drinks to first responders, law enforcement to give up community and to use themselves. And when she brought some drinks up to the department, we were talking to her about some of the things she does, and she mentioned that she does stickers and things like that. So we actually approached them about trying to reduce our costs of stickers. The last thing I'll add is the department's working with the staff at County Gate to recognize students who exhibit soaring behavior. The department purchased youth bicycle helmets as a reward for those students, and the helmets will be given out quarterly until the end of the 23-24 school year. So the way this works is that our school resource officers at the county K-8, Monday through Friday, varying times throughout the day, depending on the call load we have in town. The soaring behavior characteristics that the school is looking for are safety, orderly, achievement, respect, individuality, neighborly, and growth. And out of those characteristics, our school resource officer looks at safety, respect, and neighborliness. And if he identifies a student at the school who's exhibiting those characteristics, he gives them a soaring ticket. And then what it is we put their name on the ticket, and it goes into a drawing. And then it's broken down into distinct age groups. So the kindergarten through second grade is one age group, third through fourth is one, and fifth through eighth is the other. All the names get put into a drawing. They draw one name from each age group each quarter, and the winner gets a bicycle helmet that we purchased from a local vendor, SK Bikes. We purchased those helmets at nearly 40% off retail price, and we purchased enough to get us through the entire school year.
Thank you. Any questions for Chief Lamage?
Trustee Schwartz.
Oh, go ahead, Trustee Schwartz.
Yeah, I just want to say thank you, Chief Lamminger, for explaining these last two items. Mayor Smith and I, when we were reviewing disbursements, we thought we would ask for some additional clarifications, and we just really appreciate you explaining this again in the matter of transparency. So thank you.
Thank you. And I just wanted to ask, are you planning to do, did you say, are you going to do soaring again in 25?
Yeah, so the soaring program is actually through the school. They developed that. We would like to be a part of that. Whether the bicycle helmets continue, we'll kind of evaluate that at the end of this year, this school year, which would be in May. The helmets seem like a really good fit, partly because we're watching these kids ride bikes every day. Given recent events we've had in town, the helmets seem like a really good idea. And so far, it's been well received. So we like that feedback. But we'll evaluate this program like we do all of them sometime in the spring, probably.
Thank you. Anybody else? Questions? Yes.
I would just say, I think that's a pretty nice premium to give the kids for a token of, and make them, a little more safe while we're at it, giving them something to get used to wearing.
I mean, they seem to like them. And the folks over at SBA were extremely helpful in helping us pick out sizes. Others that seem to be popular. So thank you to them as well.
Thank you. Appreciate the updated information. Well, on that note, why don't we go ahead and start on action item number 1, which is a continuation of the meeting regarding the proposed ordinance regulating short-term rentals. And we will definitely be taking public comment, and there'll be a 3-minute limit on everyone's comment. And we'll, of course, everybody in the room, and then I'll try to be super vigilant about seeing people on Zoom, because I know it's a really nasty night out. So there may be more people on Zoom than I can certainly see. So with that, I'd like to turn it over to Administrator Nguyen to just maybe pick up where we left off 2 weeks ago and some information, comments you received, and information you found as you see fit.
Sure. So what's in front of you and what's provided for the public is some written comments that we've received from both for and against regulations for short-term rentals. And then also some research that I did based on some comments that we received as well. There was 5 citations that were provided to look into, and I did some more a deep dive into them. The one thing that did go out after our last meeting was a survey, and I wanted to share the results of that survey with you. Can. Oh, boy. Okay. It was a pretty short survey in which we received 60 responses, but not everyone chose to answer each question. First question was, we want to know your relationship to town. 35 people said they live within town limits. 13 said they live out of town limits but have a Paonia address. 2 had said that they own property in town but do not live in Paonia. Own property in town and currently rent as a long-term rental. There was 1. Own property in town and currently rent a short-term rental. There were 2. Plan to rent property that they own in town as a short-term rental. And that was 1. Own property in town and live in town. 15. Plan to or currently rent a bedroom in my primary residence as a short-term rental. There were 3. You can see the breakdown of all of those responses there. Let me see if I can zoom in a little bit. Another question was, did you participate in the 2023 Housing Needs Assessment and Action Plan process? 19 responses said no, yes, and 40 said no. So that was a very large outreach process that took about 6-7 months. That was Urban Rural Continuum who completed that process. Number 3, what do you think of the currently proposed cap of 40 on short-term rental licenses? The currently proposed cap is based on a recently completed study of active and booked short-term rentals operating within town limits, showing 38 short-term rentals currently being active. Consideration for the currently proposed cap of 40 is due to regulations requiring that individual bedrooms also require separate licensure. So digging into this information, there were 14 that said just right, 31 that said too many, 9 that said too few. Breaking down into the too many, there were quite a few that said that they would like to see anywhere from 25 to 30. Now, a lot of them had also said 20. So it's just, and that is coupled with question 4 is, what do you think an appropriate cap on short-term rental licenses ought to be? Keep in mind that the housing needs assessment discussed caps of 20 to 30, but no definitive decision was made during the public outreach sessions. Please see the image of the consultant's report from the 5/9/2024 meeting that showed an image of that report. I mean, some people took this and maybe gave facetious answers, like 81,428, that's our zip code. 10 was another answer, but we did get some pretty good data that was available that I think I sent to you guys as a breakdown, but it was quite a few pages. There were some people that discussed regulation during this question, like instead of a cap, limit all STRs to owner-occupied dwelling units in residential zones. Non-owner-occupied dwelling units used for the purpose of overnight lodging should be considered hotels and require commercial zoning fees, taxes, regulations. Here's one of them that said too many, and the response was 30. So here's another one that says, I think that whole home rentals ought to be by the year and not more than 25. No more than 25 of them ever home rentals ought to be by the year. So again, that's one that said too many, said 25. No limit, which I can't recommend no limit. That's just not reasonable. 20 could be adjusted upwards if STR owners can demonstrate demand exceeds supply. 40, at least 50, and then some more policy discussion. 20, consider the impacts of having no additional housing resources before capping STRs. max of 25 total. I can see 30 being an okay medium, and generally cap or regulation needs to take place, so we're going to script on this issue. 50, 40 is good, 100. ADU for kin, not public. There's a conflation of ADUs and short-term rentals. We're tackling short-term rentals right now, not accessory dwelling units. That's going to come at a later time. 20 statistically prove that this new proposed regulation will make the community better somehow, or somehow better. 0, 10, 40 seems to be just right. Don't want the town to get sued. I believe the cap for R&B rentals should be no more than 20, including ADUs, single rooms, and entire homes. There are way more than 40 now. I'm guessing at least twice that currently. 15 to 20. I think that regulation of what is allowed is much more important than the cap number. And the majority of the proposed ordinance does have regulations. I don't believe there should be a cap. Again, I can't recommend something that doesn't have a cap. That's not reasonable. 30, an unintended consequence of the above may be higher rents, property values in the above plan. Not sure of an exact number, but there should be not so many places sitting empty when there are people who are in need. 20 max, let people be free. 20, 40 to 20 with a revisit out every 3 years. 20 to 30, there are plenty outside of town limits too. STRs should be treated like commercial properties because that is exactly what they are. Tax them as commercial properties, charge them commercial utility rates. That's something that this proposed ordinance didn't consider, was changing that to commercial. Other communities like Breckenridge, which I'll go into detail later, does have an occupational business license and makes everyone, regardless of if it's a primary residence, single bedroom, or studio, also get an occupational business license, something we don't have in town currently. 20 STRs of prioritization given to local second homeowners if possible. I'll allow you to make that decision. I trust the people in charge here. One might be a little facetious. 25 full rental units in city limits up to 30th, including rooms and host rentals. 40, I think it should be a percentage of housing versus a specific number. I'll go into a little more detail about Summit County and Breckenridge, where there are percentages, and we're pretty close, if not less than their percentages. Establishing what people can do with their property. That seemed to be a theme that I saw in other responses as well. 25, 50, 20, 40, 20, 40, 20, and that was it for those. What specific regulations or changes to proposed regulation would you like to see on short-term rentals? There were some pretty good things that came out of here, but they were already in the proposed ordinance. This one was saying that C1 zones should have STR use by right, required to have licenses, but the number of licenses in C1 zones should not be restricted. That's kind of tough to do. I think there should still be a cap on the number of available licenses. I would recommend that. Especially when you go further down Grand and we have spot zoning for commercial C1 amongst residential. I think that doing this would make it difficult to kind of enforce. If a dwelling unit is used for overnight lodging less than 30 days, it should be treated as a hotel. People who live in their home and rent a home room within the same building should not be allowed to do so without regulation. And we're essentially regulating this to say what you can and can't do. They pay business tax in town and have county license. So the proposed ordinance also has a provision, should a referendum be made that puts a local tax on short-term rentals, that's what it would take, is it would take a referendum vote to implement a new tax in town, especially on short-term rentals. It's there in case we decide to do it, but that would take time. Right? I think it's more important to get this regulated and under control. No pets. I mean, that sounds like, I don't know, that's not something we're going to regulate. That's up to the individual homeowner. You should broaden the types of STR allowed throughout town. A mix of lodging options support local economy. License should be required for STR of an entire house, a detached ADU and attached ADU. A license for a bedroom in a house would be required and cost less.
And this is exactly what the proposed ordinance does, right? All STRs need to be up to some standard codes listed in your draft. There's a provision for that as it relates to like fire safety, egress. Short-term rentals are the number one threat to Paonia, or communities like Paonia, and should be treated as such. No additional short-term rentals should be permitted in Paonia. I support the treatment of rentals of single rooms and occupied homes differently with full home or ADU rentals. I support the requirements of STRs to be inspected for a $500 a year town fee to be applied to all STRs and for locals to be prioritized for STR permits for non-locals. And so the proposed ordinance actually does prioritize local homeowners renting out a single bedroom in their primary residence. That licensing fee is less. Cap at 100 within city limits, I wouldn't recommend that at all. But require a percentage fee of STR revenue to return to the town. Breckenridge does that. This grows revenue for the town in respect to the growth of the STR industry and doesn't cap revenue for the town at $500. A tax or fee similar to that placed on motels, that would be a referendum vote. It's a new tax. A special license to operate a short-term rental with fees or taxes which benefit the town. And that's what this is. We're licensing and regulating. Where I grew up, short-term rentals are taxed 40% to the county, and the fee to obtain a license is hefty. I was surprised when I moved here to hear zero regulations are in place, and zero benefits to the local population. I know many short-term rental owners do not live in town or even in state. I don't know how that statement, I can't verify that statement. I do know that I do have, there are properties on 3rd Street that it is a second home, they don't live in town. Then we also have on 2nd Street or 3rd Street that's operating, and it's their primary residence renting out a single bedroom. I know that from my own experience. Adequate parking upkeep of rental property, that's contemplated in the proposed ordinance. I personally would like to see stiffer fines for violations. We did have to reduce it from 1,000 to 300. That was a recommendation of the town attorney because of some criminal code where we, if the fine is over a certain amount, we would have to provide attorneys and for the defense and everything because then it becomes a criminal fine. Whereas $300 per occurrence per day is not. None. Would like a lower number than 40 for STR should have extra tap. We have a water tap moratorium, so I don't know how that would work with trying to get regulations in place now. Let's see, regulations to discourage whole house STRs in favor of single room or ADU rentals. Again, we have an incentive. It's a lower fee. Need to be licensed, taxed at a higher tax rate. Been over that one. None. I'd like to see no short-term rentals in town limits. Limit to hotels, hostels with business license. We don't have a business license. Love to get one in place, but that was a conversation a few years ago that fell on its face. I'd like to see specific regulations short-term rentals that prioritize fairness, community stability, and equitable opportunities. These include owner-occupied requirement. Short-term rentals should be operated only by homeowners who reside in the property or on the same lot. Residency requirement, homeowners must live in Paonia to ensure they are active members of the community and not absentee landlords. One rental per person. A single homeowner should be allowed to operate only one short-term rental property to prevent monopolization and encourage fair distribution of opportunities. The annual lottery system, to introduce a lottery system to allocate STR permits. This isn't permits, this is a licensing. There's a difference between a license. Ensuring new people have a chance to participate each year. A license can be revoked for failure to follow through. Ensuring new people have a chance to participate each year. This promotes inclusivity and prevents a monopoly by a few individuals. No grandfathering. Avoid grandfathering existing short-term rental operators solely based on prior participation. All applicants should be subject to the same regulations to ensure equity. Low cap. Give licenses with terms that expire so that it's not like one landlord can monopolize all the licenses. This proposed ordinance has a cap and requires an annual renewal. Specific lodging taxes, no restrictions on in-town residents who choose to operate STRs, a way to supplement expenses to live here. So that's something completely different than what we've seen on some of these towns. It's not limited to zoning restrictions like R1, but case-by-case basis. I would like to see some of these people give back to the people who are the backbone of this community, a reasonable place to rent.
lodging taxes, again, I've explained that one, live and let live. They need to be licensed, and if the STR is a whole house review, they need to pay commercial taxes such as lodging taxes. That's something we've been over already. Having insight into short-term regulations, I would definitely include an inspection that the rental meets fire safety and health standards. I propose the onus on the owner to pay and provide the city with a current inspection report. That will help keep the city held harmless in cases of negligence or malfeasance. We also consider looking at other sections of your code, such as fire, can require sprinkler systems or hydrants for each room rented. I would also suggest including a registration and renewal process or a deadline dates to register the STR. I agree with the consultants that fees should be collected at amounts based on the type of STR. Number one priority is to have clear definitions to close loopholes, require business licenses and registration with the state if required. A lot of the proposed ordinance already has some of this in here, but there are some things that are really, really restrictive, like sprinkler systems that I think would be really, really hard for somebody to put into place. And then again, require business licenses. You don't have that. License fee of $5,000 to $10,000. That's one way to stop any licenses. Density limits, stay limits, yearly use limits, nuisance ordinance, license laws, lodging tax, local owner manager, commercial property tax rate. I think only 25-ish STRs should be allowed in town because they take housing from locals. I think just renting out a room in your house short-term is better because it doesn't take away housing from the person. $10,000 annual licensing, mandatory owner or manager living within 15 miles of town. Taxed heavily, see above. Second homes used as ADRs or maybe STRs should be zoned as commercial and taxed as such. Would like to see free food vouchers. I as well struggle with out-of-state property owners buying property just to rent out. I believe I have lived or plans to live in an area for an allowed amount of time. Complete ADA compliance and accommodation make each property available to abilities. Disciplinary actions for unlicensed, still operating and licensed out of any county. I'd like to see no cap on secondary auxiliary units and a percentage cap on standalone units. Tax them as motels, hotels are taxed. Quit wasting money on consulting. If you are that inept, then you should be in your position. Ensuring adequate parking off-street for additional traffic. Giving neighboring properties an opportunity to get notified and state their views on a business, such as this in their vicinity, making sure that neighbors are both notified and have an opportunity to state either their support or opposition to a business in their neighborhood. Higher tax or fees for short-term funds go to help establish long-term housing for permanent residents of Paonia. I like proposed legislation. Can't turn long-term rental into short-term rental. Taxes should be assessed and collected by the town. Business licenses should be required, none right now. I would like to see a cap of 20 on short-term rentals, as well as additional tax or fee on homes that are not primary residences. The rest of the responses are names and email addresses that I don't want to present. We haven't had any public comment. So,
is there anything else you wanted to discuss before I ask the trustees if they have some comments or questions, and then public comment?
Sure. I mean, I did. So we did receive some comments. I should go into the citations. So we did receive some comments that they were available for the public that included 5 web links to different articles about different communities and what lawsuits that have been presented to them. I actually went in and found the complaint for one of them that was talked about, Summit County, and that's where Breckenridge is. And that case number went before the U.S. District Court in Colorado. And I took this analysis directly from reading the complaint, evidence submitted to the court, the final determination of the court to dismiss the complaint, of which the county prevailed, that they were able to dismiss the complaint that was brought on by short-term rental owners for regulating it. Summit County is a little bit different, right? They're a county. They're not a statutory town. We're not a home rule or charter community. We have to follow state statutes. And Summit County has operated with some form of vacation rentals since like the 80s. I mean, it's been a very historic thing. They didn't start regular. So They didn't start regulating that until 2018, but they incrementally have added restrictions since 2018. And they started the conversation in 2017 when their affordable housing, workforce housing was dwindling and prices were going through the roof. They began hosting their community forums to help form a regulatory ordinance. In 2018, the first short-term regulation Summit County was passed, and the planning staff operated under them until 2021. That regulatory ordinance imposed occupancy limits, required property owners to devise plans for parking and trash disposal at the property during STR stays. It mandated identification of a responsible agent for the property that we call a local contact person. Should STR guests or the county require a readily accessible point of contact? Fire, right? If there's a fire in the property, who do you get a hold of? So that like Black Hills Energy can shut off gas gas service. So that EMEA can shut off electric service. Where's those panels? That's important stuff. Mandated, made permits non-transferable. So this was permitting. It wasn't licensing at this point, it was permitting. Made them non-transferable, requiring a new owner to apply for an STR permit upon the transfer of title. Meaning you no longer say that this is operating as an STR and selling the property. Somebody wants to buy that property and make it as an STR. So all of these restrictions that were put in 2017 are contemplated with the proposed ordinance. Summit County's 2018 ordinance did not impose a cap on the number of available permits and had no booking limits. And again, this is only for unincorporated areas of Summit County. Peonia's proposed ordinance has a cap on licenses and doesn't impose booking limits. In 2020, Governor Polis authorized HB 2010-93, authorizing boards of county commissioners to license and regulate STRs. And so that's why all of a sudden there was this jump to regulate short-term rentals and make it a licensure program. Summit County directed planning staff to develop a plan to transition from permitting to licensing. In May 2021, Ordinance 20 was up for its first read, which regulated STRs and required licensing instead of permitting. June 21st, the ordinance was adopted. September 30th of 21 was the deadline for STR owners to convert from a permit to a license. On September 14th, a 90-day moratorium on new STR licenses was approved and enacted on September 18th. But renewals and conversions were unaffected while planning staff developed additional regulations. In September 2021, Ordinance 20-B was enacted that created overlay zones and updated the county zoning ordinance. So now they have overlay zones. We don't have overlay zones. And, an overlay zone is kind of like a special zoning district over that goes over other districts. And in this case, they created two zoning districts. What I think they called it a neighborhood overlay zone and a residential overlay zone. They proposed 3 licenses. Type 1, STR is the property owner's primary residence. We have something similar to that proposed ordinance. Type 2, neighborhood overlay zone, could apply for a Type 2 license, but the Board of County Commissioners capped the total nights per year for which it can be rented to 135 nights per year. Type 3 license, these licenses have no limits on the number of nights, and property could serve as an STR, but property owners have to be first to be approved through the conditional use permit. We call it a special use review here. Peonia's proposed ordinance has 2 types of licensure, one for renting out single bedrooms within a primary residence that must also go through a special use review and receive a favorable outcome to get a license. This favors local homeowners because the licensing fee is far less than a regular whole home short-term rental. Peonia's proposed ordinance also requires a favorable finding in a special use review for all licensure in both R1 and E1 zoning districts. The ordinance also imposed occupancy limits to 2 guests per bedroom plus 2 additional guests. The proposed ordinance also has this kind of occupancy limit. May of 2022, a second moratorium was acted, this time for 9 months, again to give planning staff more time to propose additional regulations on STRs. In 2022, the Summit County voters passed a 2% STR lodging tax on all STRs booking limitations within the neighborhood overlay zone. So they call that NAS, NOZ. Limited the licenses in NAS to Type 1 and Type 2, no Type 3 were allowed. And definitions for a qualified occupant stipulated that they must live in the home for Type 1 license. Stipulates that an out-of-state resident can't be considered a qualified occupant. Peonia's proposed ordinance gives certain privileges for owner-occupied STRs, such as a lower license fee. Type 2 licenses are capped Again, these are unincorporated areas of the county. The Lower Basin, which is 15% of properties, Snake River Basin, 5% of properties, 10 Mile Basin, 6% of properties, and Upper Blue Basin, 18% of properties. Paonia's proposed license cap is 40 of the 755 properties identified in the housing needs assessment that was found on page 28, or about 5% of all properties in town. Each cap on licenses in Summit County is lower than the number of actual STR licenses in each basin. The county plans to lose them through attrition, but is allowing those property owners to operate until they either need to renew or sell the property. In 2023, the Board of County Commissioners updated STR regulations limiting rentals to 35 bookings a year for non-resident owners in the neighborhood zones or that neighborhood overlay zones. The final decision of the court. So this was a lawsuit that was dismissed. County Commissioners won. Said this court is aware of the significant consequences of the ordinance and this order for property owners, residents, and visitors to Summit County, and perhaps in similar communities across Colorado. Plaintiffs in this civil action undoubtedly participated in the political and legislative process to the fullest extent allowable by attending meetings, objecting to the proposed language in the ordinance, and ultimately litigating the issue before this court. Their grievances, concerns, and the potential financial repercussions of the ordinance are valid. It is important to clearly denote the role of this court, which does not include second-guessing the legislative process or creating policy. Rather, this court must determine the constitutionality and legality of the ordinance, nothing more and nothing less. As the U.S. Supreme Court has previously noted, of the municipal council deemed any of the reasons which have been suggested or any other substantial reason a sufficient reason for adopting the ordinance in question, it is not the province of the courts to take issue with the council. We have nothing to do with the question of the wisdom and good policy of municipal ordinances. If they are not satisfying to a majority of the citizens, the recourse is to the ballot, not the courts. Defendant's motion dismissed. That's the Board of County Commissioners, had been granted 6/5/2024. Other things to note. Summit County is not a statutory town. Summit County's explanation in restrictions to Paonia's proposed ordinance, which this court case supported. Summit County took an approach to regulation over 5 years. It's actually 6, started in 2018, and allowed for significant public feedback similar to what Paonia has done and is doing. Summit County restricted the number of licenses per basin, but only for new licenses, and are allowing existing STRs to operate under a license of the cap, with plans to reduce them through attrition. I did give some explanation for licensing caps, and in a response to comments that we received from a resident. And I went over this in pretty good detail, I think, the last time, of how we got to 40 caps, or that 40 license caps. We did a demonstration with a short-term rental regulatory program software. We found 38, this was in June and July, 38 active short-term rentals within Paonia town limits. And so we were able to drill down to look at what is the outline of Paonia town limits. There was one on Price Road, but Price Road isn't in town limits, so it can't be considered as something that needs to be licensed. There were 38 operating, and that didn't take into account single bedrooms in short-term rentals. That's why that 40 cap was proposed. I did go over some of the other communities that on the Western Slope that have license caps. Carbondale has no cap, but they only allow STRs in one zone, and they don't issue any more licenses outside of that historic commercial zone. Durango has a cap of they have different caps based on different zoning. Let's see, Ridgeway has 50 available STR licenses, but does not consider the rental of a single bedroom of a primary owner occupied residence as counting towards that maximum number of caps. So anybody in R1 could rent out a bedroom, get a license, but it doesn't count towards a cap. In our case, we would, in Paonia's proposed ordinance, they would have to go through a special use review in order to even be considered for a license. As for safety regulations, nearly every community with short-term rentals has requirements that a working fire extinguisher be on site, working carbon monoxide detector, working smoke alarms, property address and contact and emergency contact info posted on site, information folder with owner's info, agent, trash, and recycling info is available, and that there was an exterior egress door at least 36 inches wide. Another item contemplated is a preference for only allowing locals to have STR licenses. And the memo from Urban and Rural Continuum says there remains a desire to only allow local staff STR licenses, but it's unclear whether this would be legal without creating a tiered system, or non-locals are also allowed to have STRs, which doesn't achieve what was being heard during the meetings. To check with our legal counsel. Boulder established rental license requirement on the books since '96 and has regulated short-term rentals since 2015, making it easier to restrict who can and can't operate a short-term rental. Let's see. There's already a preference. So our proposed ordinance, you've heard, there's already a preference for local homeowners for short-term rentals, get a reduced rate. Let's see. Breckenridge. So Breckenridge has short-term rental regulations, and this was taken from actually researching their ordinance and their short-term regulations webpage. They've been regulating short-term rentals in depth since 2021. The chart below also shows that they've grandfathered in existing short-term rentals and plan to lose them by attrition. Peonia's proposed ordinance with a cap of 40 licenses also grandfathers in existing STRs, but regulates them and doesn't allow for new STRs to come to town. Title 4, Chapter 6 of Breckenridge Municipal Code regulates short-term rentals. It's very similar to the proposed ordinance or the proposed code for Paonia, but their fees are significantly higher than our proposed fees. Theirs are $400 per bedroom or studio and $765 per bedroom or studio in an accommodation unit. They call it an accommodation, and they call a short-term rental house an accommodation unit. This also doesn't, they also have to get a business occupation license or a business license. So that's an additional fee for anyone to operate. Let's see. Their cap on STR numbers, they allow a 100% in their resort zone to be licensed as STRs, 92% in their zone 1 to be STRs, 51% in zone 2, and then their largest residential zone, zone 3, 10%, which means that 52% of their properties can be licensed as an STR. The cap allows for 4,016 licenses, but they have an existing 4,336. Again, they plan to lose them by attrition. The proposed cap in this ordinance is 40. It is 5.3% of our proposed or of the properties operating in town. And to show my citations, this is the complaint and evidence, 108 pages that went to the U.S. District Court in Denver, of which Summit County won a motion to dismiss. And then this is the actual order giving a motion to dismiss.
Okay. Are there questions for the administrator from the trustees? Anybody on Zoom?
Yeah, I have just a question, and then I'm so anxious to hear public comment. And that is, can you just summarize what taxes are currently being paid by short-term rentals? Is it just sales tax?
No, so we also have to pay a lodging tax, but it's county specific and state specific. There's no local lodging tax levied on it. That would take a referendum vote.
Got it. So right now, the only thing short-term rental folks pay are county and state tax and no sales tax, because it's not really a sale.
I believe they have a sales tax as well. I'm sure you're going to hear from short-term rental owners tonight who can tell you how much taxes they are paying.
Okay, thanks.
Mike or Lucy?
Not at this time. Thank you, Mayor.
Thank you. So with that, having heard the introduction, this would be a time to take public comment. So if you raise your hand, I will call on you. Come on up to the podium. And I believe we have a sign-in sheet, but publicly, just give us your name and whether you live in town or out of town. But if you'll put your address on the sign-up sheet for our records. So I'm sure there's some people that want to come up and speak. So give me a hand. All right, raise a hand for anybody who wants to come up. Hold on, thank you.
You do have people.
Okay, I'll get them next.
Andy Ford, I'm a homeowner here. It's primary residence. So yeah, I had 2 points I'd like to make. One is it seems like if it's your primary residence that you're trying to short-term rent here, it's kind of a different situation. If you live here 200 days a year or more, and you're wanting to short-term rent your place just when you're away on vacation or something like that, the less than 165 days that you're not here or less, it seems to be a different situation. And it wouldn't be replacing long-term rentals, because if you're living in the property, it's not on the market, right? So it seems to be a different situation. So I don't really understand kind of limiting someone who's trying to rent their primary residence when they're away. The second point I had was the 36-inch minimum door opening. Not really sure what we're trying to regulate there, unless that's an ADA standard. But if a house is not ADA compliant, for example, it has steps that lead up to the house and then the door has its wide opening, doesn't really make sense. So for requiring all of these short-term rentals to be completely ADA compliant, that's one thing, but just picking the door opening to be 36 inches wide seems to be unnecessary. That's all I have.
Thank you. Anyone else? Ms. Watson?
Suzanne Watson. Okay, this short-term rental ordinance, you will be changing the land use code. We have laws in this town that you're not following. And that is in chapter 16, article 14. There are rules about changing the land use code. The town may from time to time amend any regulation or within such district or any other provision of this chapter. They're talking about chapter 16. 16, 14, 20 says, amendments to this chapter shall be considered by the Board of Trustees only when the following requirements have been observed. 1, request for amendment may only be presented by, they're talking about legal title owners, but I'm going to shorten it to by the Planning Commission or the Board of Trustees. And 2, each amendment shall be submitted to the Planning Commission for its recommendations. Such action by the Planning Commission shall be filed in a report to the Board of Trustees. And then finally, 16, 14, 30, Board of Trustees public hearing. Prior to the final adoption of any amendment to this chapter, the Board of Trustees shall hold a public hearing thereon. Notice shall be given as provided in 16-16-10 of this chapter. And that's advertising it in the paper of notice at least 15 days in advance of the hearing. None of this has happened. And I am the chair of the Planning Commission, and I will swear to you that we have not submitted a written report to the Board of Trustees. That being said, in chapter 16 of our code, we have renting of rooms is a use that's permitted by right. It's already permitted, renting of rooms. And it drills down on single unit dwellings, and it talks about how many people you can rent rooms to. It talks about parking regulations. Your ordinance is contradicting the regulations that we already have for people wanting to rent a room in their own house. I don't see where you come off thinking that you can mandate the length of time people live with other people in their own homes. There seems to be something that's a little bit of an overreach there. I can see if you'd like to make it maybe a business use, home occupations are permitted as well. But renting of rooms is a use that's permitted by right in our town code. And as far as your survey, I'm signed up with TextMyGov, and you didn't even let people know through TextMyGov that there was a survey out. So maybe it was a good representation with the number of people you got, but it really was only geared at a limited audience.
Time's up, thank you.
Okay, but I do want to let you know, you're breaking the laws.
Time's up.
Time's up, thank you. I see a hand up on Zoom. If that person would like to make a comment. I'm sorry?
Sandra Phillips was first.
I still didn't know.
Sandy Phillips, Sandra Phillips.
Is whose hand is up?
is first.
Yes, please, give us your comment, Sandy, is that right?
Yes. Yeah. Can you hear me?
Yes.
I'm Sandy Graves now. I'm on 3rd Street. I just wanted to come out representing homeowners and hosts, and I really understand the need for regulation. So thank you for going through all the hard work to do what you're doing. I really appreciate it. My story is that I've been living and working part-time in Paonia for 20 years. 6 years ago, I finally purchased a home, and I work in Paonia 1 week out of every given month by average. And when I'm not there, for the remainder of the month, I've been renting my home out through Airbnb. I want to make the so as in Paonia, we're a small town. We don't have a big tourist pull. You know, we're not like Summit County. I don't think anybody's getting rich renting their house out. It's really a 5 to 6 month rental period during the summer. There are very few people who are looking to rent a short-term rental in Paonia during the winter. Let's see, where are my notes? So it's not a job, and it's not something where people are clamoring to go and make a bunch of money by having a short-term rental that they're renting out full-time in Paonia, but it helps to be able to own a home if you can do this. And I would say most people are in this situation because it feasibly doesn't really make sense because there's not that many rental nights available in Paonia. While we are renting out our homes or our room in a home for a certain period of time, we're giving jobs to local people for yard work, cleaning, the plumbers. We do all the things. So we're doing that. We're also working really hard to be Airbnb hosts. We have a lot of responsibility to Airbnb, and I think the VRBO people do as well. To keep our ratings up, we have to keep the place really nice. It really, we work hard to do this, and we don't make a lot of money. I pay, $1,000 in property taxes a year, and this year I'll pay more than $2,500 in short-term rental taxes. So I'm paying, just in taxes, over $3,500 this year. Most of my guests are people who are visiting friends and family, people who are, coming home for the holidays, and, so happy to be in a home that feels like where they grew up because it's next door to where they grew up. I rent to people who are here to work, people here for the Solar Institute.
Graves, your 3 minutes are up. I'm sorry. Thank you.
Okay. Yeah. Thank you so much for your time.
Sure, thank you. And I can't tell if there's another hand up, but I would like to ask if someone in the audience would like to come up and speak. Yes. And then I'll do that hand up at Zoom if I am still seeing a hand. Is that right? Okay, thank you. Sorry.
Hi, thanks for that comprehensive review, and for having us here to
Give us your name.
Oh, yes.
And in
Sorry.
town or out.
My name is Delaney Rudy and I live in town.
Thank you.
I feel incredibly fortunate to be able to own a home in Paonia. It feels like something that wasn't like, I think for many people my age didn't feel like a possibility ever, and things kind of fall in line to create this kind of opportunity, and I want this community to be able to grow in folks who live here and are contributing to the community. I want to just give a couple different examples of similar towns of a similar size that have had different experiences. So the town of Mancos in some of the prep material, their regulations were discussed. It's a town of 1,300, similar size. To obtain a short-term rental business license in Mancos, if it's in a residential zoning area, the owner has to live on site. And if it's in a commercial area, the owner must live in the area code. And Mancos continues to be a thriving community of people who can afford to live there. As a kind of contrast, my fiance, who wasn't able to be here tonight, grew up in Gardner, Montana. And when he was growing up there, the population was about 1,300 people. So again, a similar size. There's no zoning and no restrictions there. And they've seen the population plummet to only about 700 folks. And has just completely gutted the community as they know it. They're down about half in school enrollment as well. Three Forks, another community in Montana, learned from Gardner, and they banned unoccupied short-term rentals, allowing owner-occupied short-term rentals, and they have maintained a steady full-time population of about 1,900 people. So again, a similar size. And I would say Three Forks is a very similar town to Pena, a little bit less of the tourist influence than say Gardner. Again, also the speculative buying of homes for short-term rental income contributes to skyrocketing home prices, which pushes families out of the community. And I just would really love to see this community be able to support folks who are living and working and raising their children here. Yeah, and I just think of those 40 currently permitted homes, and it's 40 families that are not able to live here and contribute year round to the community. So thank you so much for your time.
Thank you.
My name is Megan.
Megan, I see your hand is up. If you would like to have your opportunity to speak, please go ahead.
Yes, hi, thank you. My name is Megan Lawson, and I just really wanted to echo Sandy's comments. I also have a short-term rental over on Colorado Ave, and I agree with thank you. I do think that there should be limits on them. I think there should be licenses, and so I support everything, all the work that you all have been doing. I do think the 40 limit is good. Because the town will not be involved with picking favorites. I was really concerned with initial very low numbers, and I was wondering what those criteria would be to decide who gets one and who doesn't. I would appreciate a consideration of a percentage of the housing stock, as we heard that it's at 40 units represents 5% of the housing stock, but I'm concerned if the town grows, will that cap at 40 seem too low to support kind of that summertime tourism economy? And then my final and maybe bigger question that I have, because I am an R1 and would require a special use permit, I'm just curious as to what the process would be, because as Sandy mentioned, we have our co-hosts, we have our cleaners, we have the folks who are already planning on their work for the coming year. We have reservations, and it would be great to have some minimizing uncertainty. Once we make those submit our application, can we continue to take reservations? Will we be in violation if we take them? Because we have reservations, we would have to cancel. If that's not the case, if I can't know with some amount of certainty, if we follow all the rules and go through this, if we'll be able to, I'm not sure how long this all will take, if there's all of a sudden a slew of folks who need to go through the special use review process, kind of how much time that will take. That's my bigger question I have for everybody. Thank you.
Thank you very much. All right, anyone in the audience who would like to come forward? Yes.
Pete McCarthy, I live here in town. I just want to center this conversation a little bit because I hear people are talking about their concerns about the number of permits and things like that. Imagine the concern and the anxiety that the renters, the long-term renters in this town have had to live under for the last 2 years while this board has done nothing to protect them. And they're just talking about possibly having it reduced to 40 or 20 or something.
Could you please speak this way so we can be sure that you are heard?
Did you not hear me?
Yeah, I can hear you fine, but this is for recording purposes. So would you please face me and speak to me?
Is that a requirement?
Yes, it is.
Robert's rules.
Yes, it is.
It is. Okay.
It is. Thank you.
Thank you for letting me know that. I didn't know. Okay. So imagine the anxiety that the long-term renters have been going through for the last 10 years. And now we're worried about lawsuits that have all been dismissed, precedent with the town of Mancos being able to do these things. We can do better than what this is. I sat in many of these things. I heard from long-term renters, we heard from landlords, and yes, the short-term, I thought one of the most amazing things was all the short-term renter landlords came up and they said, we could make just as much if we did long-term rentals, but we chose to do short-term because I don't know, it's neat, it's nice, it's fun. We have, those are 40, you said that's just 5% of the community. 5% of the community? It's not just 5% because we know that there's short-term rentals all around this whole valley. So there's probably 100 in this whole valley. That's 100 communities. That's 100 households that are no longer here, that my daughter can't go have play dates with. That this is what we've done. And now we're balancing the conversation and taking it all the way to 40. That is not a balance. We need to have relief for the long-term renters in this town. We need to find balance for them, not for the people that have been profiting at their expense.
Thank you. I don't see any more hands on Zoom, is that correct?
Correct.
Okay, anyone else in the audience? Yes, please come up.
My name is David Merrick. I live in town. I've lived here for over 30 years. I think your cap of 40 is probably reasonable. I think the proposed ordinance is probably restrictive enough that I would be surprised if you even reach that cap. One thing I want to point out is section 6-5-40 parent H2, local contact person requires this person, the owner or the local contact person, to be available 24/7, be able to respond and be able to respond physically within 60 minutes. If you read that literally, a local contact person probably can't leave town. They can't even go to Grand Junction because they probably can't get back in 60 minutes. That seems to be a little bit overkill. I don't know that there have been problems. I'm not aware of any in this town with a short-term rental where somebody needed to respond physically in 60 minutes. So I would suggest that you at least look at that section and make that a little more reasonable. Thank you. I also agree with the comments by Sandy and Megan about the benefits of the short-term rental for the community.
Thank you. Anyone else in the audience? I'm sorry, you only have one opportunity. Anyone else? Well, with that, and no one on Zoom. Okay. So one thing I would like to do is ask our attorney, if you could please address the comment made about chapter 16, article 14, that would be very helpful.
Hey, board, you guys hear me all right?
Yes.
I mean, I listened to a lot of comments. We were talking about the comment regarding the amendment procedure.
Correct.
So let me pull up so we're talking about chapter 16, article 14, amendment procedures to the zoning. I believe what the comment was something to the effect that any amendment has to be presented looking at 16, 14, 20 procedures 161420 subparagraph 2, each amendment shall be submitted to the Planning Commission for its recommendation. I think we're kind of mixing apples and oranges here. The short-term rental regulation is a legislative event. It doesn't trigger like any rezoning. Anytime a board of trustees passes a law that has some sort of effect on the zoning chapter, doesn't trigger a review by the planning commission. This particular section is talking about amendments, and if you read the first paragraph, it's talking about amendments that are presented by legal title owners of real property within an area proposed for a change. And so the zoning issues are mostly quasi judicial if and when they are only affect one or a small group of property owners. When the board of trustees takes action that affects an entire group of people or the entire jurisdiction, the Supreme Court's well settled, and I'm talking about Colorado Supreme Court, has made it clear, and I need to find that case law again, but it's made it clear that broad legislative decisions such as the short-term rental ordinance that we're looking at here is legislative in nature, not quasi-judicial, so it doesn't trigger those quasi-judicial rezoning procedures. As an example, there's been multiple counties and multiple towns that have completely reshaped their land use development code or land use code. And by reshape, I mean redefined every zone within town, remapped every zone within town, and accordingly like rewritten every law, term and condition and use that affiliates with that zone. But because of the broad nature of the law and the way that it was written, it was not considered a quasi-judicial function. It was considered legislative in nature. So I think the chairperson for the planning commission that spoke regarding this would be correct if this was an amendment that is trying to change like a particular piece of property within the town or rezone a block or a couple of properties that were affected. But insofar that the short-term rental ordinance affects everybody within the jurisdiction of the town, because it's as a legislative function, it affects the entire jurisdiction. I don't see that this amendment or that section has anything to do with passing this particular ordinance. There's been previous ordinances and there's going to be more ordinances to come that have, an ancillary effect on zoning. But there's a big difference between asking for a rezoning for a particular property and the board of trustees taking legislative action that has an effect or creates another use or an infrastructure or foundation for regulation. Those are, very separate topics. So I hope that answers the particulars of your question. So if you need any clarification, please let me know.
No, I think that's helpful.
It's not helpful.
Excuse me, I'm sorry, you may not speak out of the audience. We're going to continue with, if the trustees would like to start asking questions of the administrator, discussion amongst yourselves, and the trustees on Zoom, please don't let me forget you. So would anybody like to ask questions or make comments? Yes.
I've got a comment on the local representative, local contact person. I suggest that we change the language to, instead of a person designated by the owner or a owner's representative agent or representative shall be available 24 hours a day, which means that there is somebody on call at all times. And that eliminates the problem of somebody wants to go to Grand Junction.
Go ahead.
Can I-
Mr. DeWitt?
So I think you were looking at the definition.
Yes, under definition, and that would solve that.
Well, so under local management required, it allows somebody to go to Grand Junction under H2, where it says respond within 60 minutes in person as necessary to emergencies, any municipal code violations and or complaints regarding the condition, operation, occupancy, or conduct of the occupants of the short-term rental, and take remedial action to resolve such violations and or complaints. That's saying if it's not rented, they don't have to be here, right? So as long as if somebody has rented it, then that person needs to be available to respond within an hour.
Say what page that was on, you were just reading.
I think
That's on page 51.
Thank you.
Page 1. Page 2,
H2, correct.
replacing the word
The local,
A would solve that problem.
a local contact person. I see what you're saying.
Oh, so changing it to
Yes.
a local.
That'll solve all the problem.
And I did, trustees online, did you hear that? Potential proposed change under
Yes.
H. Okay,
Thank you, and I'm thinking like, if there was an issue, like, do they have to respond in person? Or is it just that they're available by a phone call? And then they could call the plumber or whomever, like, that just seems like a big deal to have someone be able to be there within 60 minutes if they were able to resolve it with a phone call.
yes.
The way I read that is they have to respond within 60 minutes. It doesn't say in person here in section 2. They have to
It does.
acknowledge. Does?
Oh, in person as necessary. That's true.
So if they have made contact with this person because they were available, that's when they make arrangements to resolve whatever complaint or problem it was. And that's where the in-person as necessary would come in, I presume.
Yeah, so, I mean, this is in case there's a rowdy party, right? So rowdy party gets out of hand, police are called. There needs to be somebody who's responsible for that short-term rental that can come and take care of it.
The owner called police, I presume. Right.
Just a thought, would it be better to make it that in H, local management required short-term rentals must at all times have a designated local contact person, in parentheses S, persons, whose contact information is on file, so it's not necessarily a single person who is made responsible for that kind of response. That might help us. And with that, have any issues with I, the local contact person must comply with provisions of this code at 69-10 D3. I don't know what that says. I have to go backwards, right?
You have to go forwards.
Forwards. You know what page 69-10 D3 is on? Let's put the paper copy comes in here.
That's 58.
Thank you. Proximity, okay. You want to look at, if you would you read that out loud?
Yeah, proximity of owner or owner's agent, all short-term rental owners or owner's agent must reside or conduct business within 15 miles of the short-term rental. The owner or owner's agent name and contact information shall be provided to the town. All short-term rentals must comply with section 6540H of this code. So it's circular. There have been edits to code made in the past where it referenced different pieces, but then didn't go back and make a reference back to another section of the code. So something got changed, and then it didn't get changed throughout the code. And so that's why this is written, just good policy.
So I would just ask the trustees with this section 3 in mind. Does it look as though there would be any problem if earlier in the code it was made plural and that person had a little bit more flexibility, like you were suggesting, Trustee Stelter? Maybe that's a good suggestion for flexibility. Trustee Stelter.
I believe that's a very good suggestion and it should work.
And administrate, oh, I see a hand is up.
It's trustee.
Okay. Trustee Hunter, please go ahead and speak.
A couple things. Thank you, Mayor. Could you repeat that last item you were just discussing? I didn't catch that.
Was that the reference to the local management required? And then we were referencing back to section 16.9-10, which was more prescriptive on the local agent. Is that the part you missed?
Well, just the latest where Trustee Stelter just said he thought that would be a good change. I didn't catch exactly what change we were recommending or discussing.
Could we have a summary by Administrator Wayne if you're comfortable?
Yeah, so there's two changes to the ordinance that are being considered. It's first one is 6540H1 and 2. Change D to A, so a local contact person instead of the local contact person. And a change to section 6540H, instead of saying local contact person, saying local contact persons with an S in parentheses.
Got it. Thank you for that clarification. And I had my hand up earlier because I just wanted to say thank you to staff. I know this is not an easy issue to tackle, and we've got a lot of community members with varying views on this. And I think that the ordinance is well thought out and it takes into account the needs and concerns of all the different residents and viewpoints. So thank you.
Any other trustees have suggestions or sections of the proposed ordinance they'd like to discuss in detail? And I see Trustee Schwartz.
Sure. Let's see. I have a couple things that I would like to discuss. There's two main ones. One is with the timing, and obviously the January 1st, that seems very unreasonable, just given staff time and the amount of time that's necessary. So I think we should have a discussion about what would make sense, because again, we do need to, like, tourists are already making plans to come to Paonia. They're already renting out their places, etc. So I do want to look at timing. So that's one issue that I would like to discuss. The second issue that I would like to discuss is the number. I remember when we were having the public meetings with Rural Continuum about the number and whether or not we should regulate people who are renting out their rooms, etc. And I think it is really good that we have there be a license attached to people renting out their rooms. And I get that that's what has increased the number to 40. There is still part of me that thinks, should we start with a little bit lower number, perhaps 30, and then we can always increase it, versus if we start at 40, then it would make it's a little bit harder to decrease it as needed. So I tend to take a little bit more conservative approach and say, let's start with 30, which would include people renting out a room in their home, and then we can grow it as necessary. It's just easier to grow than to decrease that number. So those are my two points.
Would everybody be comfortable talking about the first issue that Trustee Schwartz brought up in terms of timing? Since we know January 1 sure isn't going to work. If there's some thoughts on that? Yeah.
90 days, I think, give it 90 days before it's implemented. Yeah, after adoption.
And
or so, somewhere around there.
If you could explain the time frame from our vote to what has to take place.
Yeah, so anybody that's currently operating, so should this pass, anybody that's, there's that 30-day period before the ordinance becomes enacted, right? So if it passes tonight, the earliest it could be enacted is December 26th, day after Christmas. And then there would have to be a time frame for people to present. Sam's raising her hand, so she's got something to say about that.
You want, go ahead, Clerk Vetter?
I'm sorry, since you guys are talking about timing, I just want to make sure you have it right. So it'd be enacted 30 days after it's first published in the paper. We do have a weekly paper, and that can change your stuff up to a week. So I just wanted you guys to be aware of that.
Could you explain, so if it were approved tonight, how soon would the first publication be published?
Today is Tuesday. If I had it in by Friday, it would publish next Thursday.
Okay, and then the 30 days starts.
January 5th.
So it would have, okay, thank you. Thank you for that clarification.
Which then if you're operating in a R1 or an E1 with a special use review, and that has to go through the planning commission, has to be either recommended approval or denial, and then it goes to the board of trustees for final approval. So that's a minimum, 30 to 45 days there. I would assume that February would be really, really busy. And it would make sense that that license be in place or need to be in place by sometime in March. And that's if everything happened today, right? If we push this to December 12th, then it goes a little bit further. And so those are some considerations as well.
I just thought that no matter what date we pick, people are going to have reservations at this point. We can't fix that. So let's just go ahead and set a date and go, and we'll start from there. It's gonna bite somebody somehow, and better to do it now, first in the process, than wait until June or July when we're really in trouble. So the longer we delay, the more reservations are coming in and the more problems we're gonna have. That's my thought.
You're here.
Was that a
Trustee Heck?
Yeah, Trustee Heck, go ahead.
Yeah, I was just mumbling. I was just agreeing with him. And I think, yeah, just do it. Get it over with. We're kind of kicking the can, and we really don't have a direction that we're headed. But the 40 seems like the number that it doesn't affect anybody on the short term. So I'd kind of go along with it, I think. I think that's the way to do it. And just get it done.
Okay, thank you. I just wanted to ask Administrator Nguyen. So you'll need to be creating the administrative side of this application, be ready staff-wise. So how do you feel staff-wise to be ready when our calendar date goes into effect?
Yeah, so when considering this ordinance, I looked at what other communities had done and what they wish they had done. A lot of the application process was defined by the finance director in other communities and not codified. This proposal codifies that application process and also provides a waiting list if there is more. And, if there are more license applications that come in, it also contemplates what happens if somebody is in an R1 or E1 district. They've submitted an application. Now they have to do a special use review. This code contemplates that it will encumber that license until they either receive a favorable decision from, for that special use review, or a denial, or an unfavorable. And then it either makes that license active or that license goes back into the kitty. So it's contemplated that on the front end, rather than trying to scramble administratively down the road. When I was putting this together, doing the research, we also held department head meetings where I learned about enforcement activities. That's why some of the things were put in about enforcement. And so that's why that's there. As far as making an application, it should be relatively easy, especially with our new modules with Cassell.
I see a hand.
Just want to clarify, public comment rules, right?
Yes.
So we just public.
Yeah, I'm sorry, we're not taking any public comment at this point. So follow up to Administrator Nguyen there from any trustees? Because I have a question, but I don't want to bogart. So go ahead. So if whatever the date is that gets implemented, it gets embedded in the ordinance, are you going to be open to people contacting you and saying, I want to be on the list for an application before that date begins?
So if this passes, they would be given an application to fill out after it's finally adopted. So after that publication date, I don't want to take pre-applications, it's applications. And so that gives plenty of notice. There's plenty of time for people that have that property to know that they're going to have to get an application in. And when they are available after this notice period, they would take it at that time. And then it would be first come, first served.
It looks like Trustee Hunter has her hand up.
Yes.
I'm ready to make a motion if there's no further discussion, but I don't want to jump the gun if there's more you would like to discuss.
I think there's more discussion, and I also see a hand above, but I can't tell whose hand it is.
It's public. It's somebody from public.
Okay, but I see, I think you got a pretty visceral reaction here in the room that I don't know that that we're ready for a motion yet. Is that okay?
I have some things that need to be clarified.
Yeah, so let's hold off on that, Trustee Hunter. And if I might ask, I see Trustee Schwartz's hand is up. Trustee Schwartz, if you want to go ahead and speak.
I do not feel ready for a motion yet, but Mayor Smith, did you have a comment? Because I've already spoken once, so I want to make sure we can go around the room.
No, I was done with mine.
Oh, okay, great. So I do want us to have some discussion about the numbers. Again, I'm like the timing, thank you for answering that. I think that's just an administrative thing. And I agree that we have to pull the Band-Aid off at some point, and we need to be reasonable, both for staff and people who are existing short-term rental folks. So I just ask that we be reasonable and we give ourselves time to implement this. I do want to have some discussion on the idea of lowering it from 40 down to 30. And with that 30 being including people who are renting out their rooms. Again, it's going to be so much easier for us to go up, but I'd rather this is new for us as a community to be regulating them. And I'd rather us start with 30 and then we can build up, we can come back to the council if we need to increase it. And it would be more in line if we look at the survey that was done, if we look at the recommendations from our housing report, it would be more in line with those two things.
Thank you. I was going to ask Administrator Nguyen, if everybody could hold the thought on the numbers for a second. It sounded like Administrator Nguyen had a few other things that we need to think about, and then we can start that discussion.
Right. So what's in the packets is just a carryover from the last meeting, and it didn't include the changes that our town attorney had requested for penalties. And so one of the big changes is 6580 penalties needs to be $300, not $1,000, because of that criminal element to it. So 6580 would need to be revised.
That's on page 55 of the packet.
Yeah, would need to be revised to the amount of $300 per day. Get rid of the 150, just $300 per occurrence per day.
Is that the only place where there was that amount?
I believe
it's also in section 6.
6560.
Sorry, section 6 of the ordinance, so towards the end of the ordinance.
Oh, yes, so section 6 is what was requested by Clay.
Oh, with the preamble?
No, it would have been on page 58, let's see. Trustee Hunter must be looking at the new ordinance, the one that was revised.
Yep.
And then, so that's easy to revise, to change those things, to say $300 per occurrence per day. And change that 6580 and within section 6. And then the next one is the time, so 6580A. No, I'm sorry, 6530C.
Okay. Oops, got a page number for us?
49. Oh, no, that's the license number. It's 6588 changed to 33025. Where it says January 1st of 2025.
I'm gonna have to do a, are you in the packet or are you in the?
I'm in the packet right
Okay.
now.
Is that on section?
That's section 6530B.
6530B.
What page in the packet, Lucy?
I'm looking at the paper copy.
48.
Thank you. Okay. Which starts with definitions.
Yeah, and so in order to operate on or after January 1, it would be, I would propose on or after March 30th of 2025. All current pay and short-term rentals must be licensed. And then, actually, so that should say April 1st, 2025. All current pay and short-term rentals must be licensed no later than March 30th, 2025.
And you feel confident in being able to be ready for that?
And it would be incumbent upon those people seeking a license to get an application as soon as they can.
So the ordinance can't go in effect until January 5th?
Correct.
So, and you will be working on an application between now and then?
I already have one ready to go.
So after the 5th, people could start submitting an application?
After
right?
January 5th.
After January 5th. Okay, I want people to understand that there is now a window beginning January 5th through March 30th. And to be having a special review requires the planning commission and the trustees. And it has to be a public hearing.
Correct.
So there's at least 30 plus 15 days associated with that. So that could be 45 days. So people will not be licensed by March 30th if they have to go through the special review. That's my point. And is that an issue?
They could be, right? So if they take that application January 5th, they would also get a special use review application. And we'd want them to send them in as soon as possible. And it would be incumbent on that applicant to get both of them in. And that's only for those short-term rental licenses within R1 and E1 at this time. If they're in C1, C2, or R2 and R3, they wouldn't require special use review as it's written. And then I1 and I2 are not, and public resource districts are not allowed.
And that brings up a point. For somebody to have a single seat beauty shop in their home, they have to have a special review. And these impact the neighbors equally as much, if not more. So I think that a special review should be required for any neighborhood business such as short-term rental.
Are you referring to beyond R1?
Yes, R2 and R3 as well.
That would change this considerably. I mean, it would change the text.
It would change text, but it would be just a few sections. So
that, okay, if I can be, so if that's the case, there are gonna be an awful lot of special reviews going on simultaneously.
there would be, yes.
And are we really equipped to do that?
It's dependent upon your planning commission.
I'm on the planning commission. And I'm sorry, but I don't think that's practical to start out with. To be asking almost everyone who currently has an STR is going to be in 1, 2, or 3. Maybe a few C1s. Rooms, no, yes. There's one instance of rooms in the C1.
And there is somebody who's chomping at the bit to get one in C1 as well.
Right, but do you really think that's practical to get done by March 30th? I'm not against it. I just think we need to think about what our capabilities are. Because that's a lot of public noticing. Each one has its own public notice, its own notification to everyone within, what, 200 feet?
500.
Yeah, I mean, if that's the case, I think you have to let this go further out. We can't, I honestly, I can't see being able to do this many public hearings in 3 months.
Well, the longer it gets put off, though, the more it gets into the rental season in spring, summer. When
You want to be on the planning commission? Sorry. Sorry, there's a practical issue here. If you were to make, it's almost, you would have 38 licenses coming in. I'll say 35 licenses coming in with special review.
There's a good chance. If it were R1, R2, and R3.
Right, that's my point. If it's R1, R2, and R3.
And my
That's-
point is the neighbors do have the opportunity there to support or oppose.
No, I think
this.
I understand what it is. I don't think it's practical at this point to have 35 public hearings.
Their license
3 months.
is held until they get it. When they apply for the license, it's held until it's denied or approved. So if it goes beyond that, we don't have to worry too much about it.
It's not a lot of, that doesn't make me feel a whole lot better.
No,
In terms
it's
of
a tremendous amount of work.
Yeah, the administrative thing here. I don't know if you have staff to do 35 public hearings in 3 months. So anyway, I'm just throwing that out there from a practicality standpoint.
we don't move as fast as you do.
Oh, yes,
I wanted to add cost factors because certification has to be sent out to the neighbors and each one's $10.
each certified letter,
Yes.
and which is paid by the applicant.
Correct.
No, we pay.
We shouldn't.
It should be, it's the applicant pays for those.
It's covered in the fee, barely. It barely covers the fees.
So it is anticipated that the fee will pay for those certified letters.
Correct.
Because it can be a lot.
Yeah.
That's a good point too. Okay, well, I'm just, you've got my thoughts on this. So continue the discussion.
I've already spoken. You guys are up. I move that we adopt the ordinance.
Wait.
No.
Wait 1 second.
There's still a request to talk about the
cap.
license.
Okay.
Yeah, so, okay. And do you feel like this motion can be done in one piece, Administrator Wynn? Or you're keeping track of all the changes, so it could be as amended?
So I currently have 5. There would have been 6 if there was more support for special use review for R2 and R3, but I don't have that one in there.
With that being brought up, would the trustees like to weigh in on that, including the 3 on Zoom, R1, R2, and R3? Hey, I take that as a no.
Madam Mayor, sorry, this is Trustee Hunter. I just see that is really difficult to implement.
Okay.
I agree with Trustee Hunter. And if we were gonna go that route, then the route that I would suggest is that we eliminate R1, 2, and 3 from short-term rentals. If we were gonna propose doing special use reviews. However, that's not the route we're going, and I am supportive of keeping them in R1, 2, and 3. And wait, where am I? Yeah, I would not want to have all of those special use reviews. And if we were going to go that route, I would say let's just eliminate those from this discussion.
So just for clarification, you're saying that a STR could only be in C1 or C2?
If we were going to require special use reviews in all the residential areas, as Trustee Stelter was saying, then I would say let's just eliminate that completely. But I'm not in favor of this. And I apologize, I'm on the East Coast right now and my brain is a little bit slow here at 10:15 p.m.
Yeah.
So,
okay.
I'd like to know what a special use review entails. I mean, you publish it, notify your neighbors, and they have to comment on it, and then it goes through the planning commission to get voted on, whether you approve it or not.
Yeah, so the applicant is given a chance to talk about their application for that special use review. There's a staff report that's provided, the applicants, then there's public comment, the applicant's given a rebuttal time, staff is given a rebuttal time, and then the planning commission deliberates, makes a recommendation to either approve or deny that special use review, or make no recommendation to the board of trustees, or trustees again holds public hearing, does their thing. So you guys are gonna see them many.
You know my thoughts. So, yes.
Rick has a good point about including all the players, neighbors in this. And Walter, you have a good point about dragging it out. I think more people are gonna hate us if we drag it out until June. And we can hold sounds like we could hold the licenses until the process is done, which gives a lot of incentive to get it done. So I'm in favor of having our cake and eating it too here. Let's review the R1, R2, R3, and let's shoot for March. And if some of them tail off, I'm guessing it's not going to be as involved as we think it is. It's hard to say. That's part of the problem is we just don't know. And I think we should err on the side of get it done.
So it's my understanding if they get their application in, then it sort of holds their place in line until they get the special use review. And that could go beyond the date that it's required for them to have their license. If their review isn't done, if they just are still waiting.
As the way the ordinance is written right now, they would have to have that license activated by April 1st. So if they have bookings and they haven't completed the process, have an active license, they're gonna have to cancel some reservations.
Right, I see that as a real hardship to the people coming in personally.
Well, let's give them 1 month. Let's add another 30 days to this for the staff to get their the special reviews accomplished, and then have, instead of April, moving to May.
No matter what we do, there are going to be hardships.
Oh, yeah.
Well, right now
And
it's
even then-
March. Right now it's March 30th.
Well,
Right.
March, April first, so.
No, that's
They,
not-
they have to have that license
Before they can,
before April first. So they have to have everything done by March 30th.
Trustee Stiltner?
I've got a suggestion that we limit public comment to the people that are specifically notified within the 500-foot radius per occurrence, per the judicial, quasi judicial hearing. And that way, there'll be much less influence with it.
I'd ask the attorney if that's legal.
That almost sounds like what we'd have to do is also change an ordinance or special use review, public hearings. And it would be, we would have to check with Clay to see if that is legal, because it's a public hearing.
Right.
That's,
Do we put the question to Clay?
there'd be a lot more work changing an ordinance too. I can just tell you that.
Right,
much.
because it seems to me you cannot limit public comment at a public hearing to people that live within that.
We can limit the
zone.
amount of time they have to speak, but I don't think we can limit.
Right, I don't see how we could do that. Doesn't seem reasonable. So so right now,
Sounds like there's 2, 4, and 3 online that are saying, let's get it going. And then, I don't know where trustee Chad.
Do we need a motion?
well, we haven't talked numbers yet.
Well, I meant a motion for this specific issue.
Is it a good idea to break this up into multiple motions? I don't know the answer to that. Because it's all about the content of the ordinance. We're wordsmithing a bit.
So I guess if you wanted to make a motion on whether or not you require special use review for R2 and R3, that could be a motion that would be presented. You vote on it, we know where to go, and we can move on from there. Sam has her hand up.
Yes. Look better?
Oh, sorry. I was actually going to say much the same as Stefan just said, that since you've got varying opinions, it seems, on different issues that seem important, maybe you should do them by each motion, because then it's not muddied up by something else with it.
Thank you. So
I would like
Trustee
to
Stelter, go
propose a
ahead.
motion that we include R2 and R3 in the special reviews process for licenses.
we have a second.
Second,
Okay, more discussion? Hearing none?
Can we do a roll call vote?
Sure. All in favor?
Aye.
Do it.
Can you do a
And then-
roll call on that? Hey, Sam, can you do a roll call vote, please?
Yes. Oh, sorry. Switching between screens. Trustee Stelter,
Aye.
Trustee Check,
Aye.
Trustee Valentine, or Mayor Pro Tem Valentine,
aye.
Trustee Hunter,
Nay.
Trustee Schwartz,
Nay.
Trustee Heck.
Aye.
The motion passes.
The next, sorry,
Go ahead, trustee Schwartz, go ahead.
Well, I'm wondering if the next section that we could perhaps do the same way that we just did this is to talk about either timing or numbers.
Okay, you go ahead. What's your preference?
Yeah, I'd like to just dive into the numbers. So again, you all know where I stand. I think we should lower it to 30, including the single room. And I'd be happy to make a motion on that too.
Let me just check if there's any more discussion on numbers amongst the trustees. Okay, I say go ahead and do your, oh, sorry, trustee Check?
No, I would just give my opinion, but I can give that my vote.
Okay, so go ahead and make a motion, trustee Schwartz.
I make a motion that the total cap of short-term rentals be 30, including single bedrooms.
Second
I'll
that.
second that motion. Oh,
All right, do we need a roll call? Can we go ahead, all in favor?
I
Opposed?
Nay.
Madam
So do-
Mayor, can we
Yes.
do a roll call, please?
Sure. Trustee or clerk Benner?
Thank you. I just want to make sure everything's clear for everybody. Okay. Trustee Stelter,
Aye.
trustee Check,
Aye.
trustee Valentine,
Aye.
trustee Hunter,
Aye.
trustee Schwartz,
I
trustee Heck.
Nay.
The motion carries.
Okay, thank you. So now we are on to the topic of timing. And let me just, maybe I should let Administrator Wynn, right now it is March 30th under section 6-5-30, license required. Subsection B, in order to operate on or after March 30th, 2025, all current short-term rentals must be licensed no later than, it says December 31st, 2024. So I don't quite understand the relationship there.
This was a draft. It was a draft and we had already discussed the change.
Yeah. Well,
March 30th.
but I don't know what the March 30th is. Is it referring to?
After March 30th. And then- So the license would have to be applied for in enough time to process.
Right, we don't have a second date, I don't think, or no,
Yeah, we
January
did. We
5th.
said April 1st and March 30th.
Yes. So in order to operate on or after April 1st, 2025, all current Paonia short-term rentals must be licensed no later than March 30th, 2025.
Trustee Stelter, did you have your hand up?
I suggest that we change March 30th to April 1st. And that's applied for, not licensed, not completed. And that they be completely licensed by May 1st.
So you're saying in order to operate on or after April 1st, all current Paonia short-term rentals must be licensed no later than, what did you just say?
They must be licensed no later than April 1st or have their applications in, and the deadline for us would be May 1st.
I'm looking at how it's worded. Can you I'm really confused. In order to operate on or after April 1st, all current Paonia short-term rentals must be licensed no later than.
Licensed or applied for. Because that way we've got until May 1st to get all the public hearings done.
So May 1st.
So in order to operate on or after May 1st, 2025, all current short-term rentals must be licensed or application made no later than April 1st, 2025.
Everybody on Zoom catch that?
Yes, thank you, Mayor.
does that seem realistic for the members of the planning commission? Like, it seems that our comprehensive plan is a priority and that takes I think you all meet like once a month. It seems like a lot to also throw in all of these special use reviews. And even though I appreciate the extension, I'm still a little bit nervous that this is not enough time to go through the special use reviews.
Trustee Selter?
As the town council often meets in a work session, when we have business we have to get done, specifically the budget, that kind of thing, we often meet more than twice a month. And I assume that we can probably ask the planning commission to meet more than once a month. And
I'll just add, the trustees are gonna have to meet more than once a month, twice a month as well. I can just guarantee it. So, anyway, go ahead, trustee Schwartz.
Oh, that was the extent of my comment. Just, are we being reasonable with our timing?
And my opinion is no. What's that?
It's my standing trip to the Indianapolis Horse.
More discussion on those proposed dates?
Oh, just really quick, if I could. Just a quick question.
Sure.
As I understood it, we have like 38 people out there that qualify. What's the criteria for eliminating the excess?
You want to answer that?
It's not 38 anymore.
I don't know. So it's first come, first serve at 30.
Okay. I'm just curious how we're going to do it.
I'm gonna get yelled at a lot. At least 8 times today. It's fine. Okay, so can I go through the changes that you've requested so far? We now have 6, but one of them is more like changes to 8 different pieces. The first change is 6540H1 and 2, change D to A. The second one is 6540H, local content persons, S in parentheses. The third is 6580, penalties to $300 per occurrence per day, and section 6 of the ordinance. The fourth is 6530B, change to 5/1/2025, and add must be licensed or application made. Application made by 4/1/2025. Number 5 is adding special use review to R2 and R3, which changes section 6530D, section 6550B1, section 6550B1I, section 6550E2, section 4, table 16-1, section 16910C. And then number 6, 6530C, change to 30 STR licenses. There shall be 30 total combined short-term rental and single bedroom short-term rental licenses initially available.
I would like us to do, could we do another poll or another vote on the timing? Because it doesn't seem, I'm not clear if we're all in agreement with that or we have a majority agreement.
Is there a motion?
Yeah. Did you have a motion on the, Sam, was there a motion made on the timing? I don't think there was.
No, there has not been a motion made on that one yet.
Can you take us back to that, which rule it is?
6530B.
And do you have a page number?
Yeah, it's
48.
Thank you. So what was discussed was in order to operate on or after May 1st, all current rentals must be licensed no later than April 25th. Is that right?
No, so in order to operate on or after May 1st, 2025, all current Paonia short-term rentals must be licensed or application made no later than April 1st, 2025.
Or April 1st. Okay, 25th.
2025.
I have a question about all current. And it also goes, I'm sorry, I know we're talking about timeline, but is this like if we go to page, what page is it? 47, the top of it says the regulations set forth herein will not infringe on current operations of existing short-term rentals, but limit the creation of additional short-term rentals and provide permanent regulations for new licenses and the annual renewal of licenses. In my mind, that paragraph needs to be struck. And when it comes to the timing, it says, and it said, get rid of current. So it's in order to operate on or after April 1st, blah, blah, blah. All Paonia short-term rentals must be licensed no later than whatever date that would be. So I just want to clarify, are we only saying that the licenses are available for those who are existing short-term rentals? Because that's what that language is implying.
Okay, so it sounds like there's two more changes that are being requested. The first is to strike, and I'm sorry, which paragraph?
Number 2.
So strike the entire paragraph, number 2, under whereas.
Correct.
Strike.
Because we're not grandfathering in like existing short-term rentals. We're basically putting an open application that anybody first come, first serve, whether you're an existing short-term rental or not, can apply for.
Trustee Stelter?
And that leads to page 48, under license required 6530, section B. It says, in order to operate on or after January 1st, all current short-term rentals must be licensed. To qualify for a license, it says that you have to provide proof of ownership and then go down to 2, subsection I.
Yep.
Proof that the short-term rental was operational on or before December 31st, 2024. So that means that it's a free-for-all.
So it's saying that, or it's or. It's
Just say or, you're right.
So I'm not, because the intent wasn't to only limit this to people that already have a STR, was it? Because people wanting to create an STR have the opportunity to apply as well, right? Yeah. Or proof that the applicant's primary residence is the same property or the same property. And so do those 3 subparagraphs make it clear that somebody can start fresh with an STR that have never had one before?
You could change, let's go back, okay, because you're striking paragraph 2, which you're saying it's first come, first serve. So you strike paragraph 2, section 6530B, you would be striking
6530B.
You would be striking current. So it says, so that would be all Paonia short-term rentals must be licensed. And then 2, provide either 2I, that would have to be changed to say proof that the applicant for a short-term rental is the owner of the property.
May I ask a clarifying question? Are we all on the same page that we are not allowing existing short-term rental people to be grandfathered into this?
I think you've made that, my opinion is you've made that clear when you reduce the number of available licenses to 30. Was that, yeah.
Yes.
The clerk has her hand up.
Oh, go ahead. Clerk Matter, sorry.
Hi, sorry, I have a clarifying question too. What was the date in May that we had to be by? Because we might have a strategic issue there.
May 1st.
Okay, so what I'm seeing here is if people have their applications in by April 1st, unless we're going to get both the Planning Commission and the Board of Trustees to set special meetings for this, and I'm assuming that even with 30 licenses, that there's probably going to need to be more than one meeting, maybe, unless there's a really cool fast tracky thing. They wouldn't be able to go in front of the planning commission if they went by a regular meeting until May 5th. And then wouldn't be able to get to the board of trustees after that until at least the 27th of May.
Understand.
And the-
that timeline, Sam, you're gonna have to.
And the outcome would be, I'm confused. The outcome of that would be that unless they're in a C1 or C2, everybody needs a special review. And you're saying they wouldn't even know if they were in or out until after May 5th? Is that what you said?
Yeah,
So if this were to go in effect January 5th, applications are submitted or given for both the license and for a special use review. They could be on the March Planning Commission meeting. And then the next meeting of the Board of Trustees could hear whether or not those those special use reviews were approved or denied.
That would be on March 11th.
March 11th. And then still within April, you've still got your 30-day period. You're still fine. Sam, I'm not understanding where you would say May 5th would be.
I guess I was just misunderstanding, because if somebody applies for something and they use the deadline of April 1st, they're not going to be able to get in front of the planning commission until at least the 5th.
But it's incumbent upon the applicant to get in as soon as it's available.
So you're just saying that they need to do it before April 1st somehow. That's why I was confused, because I was like, well, we're not going to be able to meet that deadline just with notification things. I see what you're saying now.
Okay.
So January will be a flurry of activity for submitting applications. Right?
Sounds like it.
That's okay. That's the logical outcome if it gets approved tonight and published ASAP. Okay. So Trustee Schwartz, go back to your original, what was your original comment?
Just this idea of grandfathering in. And Town Administrator Wynn, I know you said that there's like 38 existing short-term rentals, but I think that number changes all the time. So regardless of that number, it's like, okay, if we agree that 30 is that number, and it's going to really be open to anybody in the community, whether or not they've had it before. So I just want to make sure we're all on the same page about that, because it does change the intent of what Town Administrator Wynn had brought forth.
And so you're striking paragraph 2. That's the 7th.
I'm proposing that we strike paragraph 2.
Well, I think you had enough support. So striking paragraph 2 in the whereas. And then 8, the 8th edit is 6530B, strike current. And then 6532I changed from to 6530I. Proof that the short-term rental was operational on or before December 31st, 2024, changing it to proof that the short-term rental applicant is the property owner.
Correct.
Okay.
And then let's read the rest of them. And then proof that the applicant's primary residence is the same property or on the same property as the short-term rental. And provide proof that all applicable Paonia sales tax was paid. Do we strike that one as well?
No, please don't. So
okay.
That at least gives me a baseline to look, especially if sales tax is submitted quarterly by Airbnb or Vrbo or bringfido.com, that allows me to look it up and make sure that has been done.
Okay, and then number 2, I really like that one. It's like proof that the applicant's primary residence is the same property or on the same property as a short-term rental.
That's for that lower licensing fee.
Oh, got it, for the single bedroom.
Correct.
Okay.
And it also is it's also a provision that allows for an expansion if ADUs are considered in an upcoming code change.
Contemplated.
Yes. I know they're not allowed.
So do we need a motion on the time frame? We do not have that. And do you need a motion for the last two, the changes that just?
I heard no opposition to 7 and 8, so I don't think so. It would be nice to have clarification on section 6530B.
It's the timing.
Correct. As it has been proposed, it is 6530B. In order to operate on or after May 1st, 2025, all current all Peonia short-term rentals must be licensed no later than, it must be licensed or application made no later than April 1st, 2025. So I'll read that again. In order to operate on or after May 1st, 2025, all Peonia short-term rentals must be licensed or application made no later than April 1st, 2025.
I'd like to make a motion, if I may, that section that was just read by Administrator Wynn, that in order to operate after May 1st, 2025, all applicants or all short-term rentals shall be licensed or applied for by April 1st, 2025. I'll second.
And then can we do a roll call vote, Sam?
Yes, just, Clerk Better, would you please do a roll call?
Yeah, oh, sorry. I'm sorry, who seconded that?
Trustee Check.
Thank you. All right. Trustee Stelter,
Aye.
Trustee Check,
Aye.
Mayor Pro Tem Valentine,
Aye.
Trustee Schwartz,
Nay.
Trustee Hunter,
Aye.
Trustee Heck,
Nay.
the motion passes.
Any further discussion on this ordinance?
Okay, I do have a question on where this is page 49. And then it's section 6.5.4, 40 conditions of short-term rental licenses. It feels like an overstretch to say what a maximum occupancy equal to 2 persons per bedroom plus an additional 2 persons per property. Do we really need to be regulating that is my question.
So yes, the short answer is yes. There's fire code. This is pretty standard in other short-term rental regulations across the state.
Okay. And then we had a question by a member of the audience. And I too had the same question, and I know that it's about the egress door being 36 inches wide. Could someone please explain that?
So 2018 International Residence Code and International Business Code already stipulate that egress doors must be 36 inches wide. So if you're going to commercialize your property, receive a license from the town in order to protect us by issuing that license, 36 inches would be necessary. It's something that needs to be done. I understand that there's some concern about ADA with steps. think of it this way, if somebody were to get up in a wheelchair, up your steps, through that door, and a fire breaks out, they still got to be able to get out that door. Or if a fire department is called, they're going to have to wheel somebody out the door. It has to be 36 inches wide. So if you're going to get a license from the town, you're getting, that's the town saying you're okay to have this short-term rental. You want to be able to regulate that, say, you got to have a 36-inch exterior egress.
Okay, thank you for that. I have no further questions.
Do we need a motion to adopt the entire ordinance?
Absolutely, as revisions are made.
Okay. Is there any more comment on the content, specific content that anyone would like to discuss? With that, would somebody like to?
I do have it. Oh, I'm apologies.
Go ahead.
Is it impossibility to ask that we be able to see the final version before we vote on it?
There's no way I'm going to have that done tonight.
Oh, I'm not expecting it. I'm thinking for the next meeting.
I have to say that would mess up the timing. We'd have to change the time frame because it wouldn't be able to be seen until December 12th. Or no, 10th is our next meeting.
Yeah.
It would be the Thursday after that, before it's published.
Right, so it would mess up the time frame.
By pushing it back a month.
Yeah, well, yeah.
Would you like me to go over the changes again, the requested revisions?
I don't need that. No, I've heard them all.
Somebody like to make a motion?
I move to approve ordinance 2024-5 regulating short-term rentals with the following revisions. Numerous revisions that we've already gone through twice.
Is that set up?
I'll second.
Who got there first? That was trustee Check who seconded. There, all in favor?
Aye.
Opposed? Did we hear from trustee Heck?
Yes.
Yes, we did.
You voted aye.
Yeah.
Okay, thank you. I just didn't hear your voice. All right.
I was in the middle of a sneeze.
Okay. All right. I had, when we changed the agenda, I had action item number 2. I think we go ahead and do this fast. Action item number 2 is, because we would like to have, we're going to lose trustee Schwartz at 9:30 because she's on Easter time. Could I ask for a motion to move action item number 2 until after the executive session?
I make a motion to move action item number 2 till after the executive session.
I'll second.
On favor?
Aye.
Aye.
All right, so we are moving to the executive session. And I need a motion to go into executive session. If someone will make a motion to that effect based on the content of the agenda.
If we go into executive session for a conference with town attorneys for the purpose of receiving legal advice on specific legal questions under CRS section 24-6-402 for the specific to ongoing litigation.
I'll second that.
All in favor?
Aye.
Aye.
Thank you. All right, so now we will move into another room.
Yes, and our clerk is going to do a breakout room. We have the Sursa attorney online representing us in this case, and also our town attorney. So they're going to join us in this breakout
Do
room.
we need another laptop in there?
I'm taking mine.
You're good. Okay.
And then we've also got cameras. So.
Okay, thank you.
Can I ask when that ordinance, the way you just passed
Go ahead.
So trustees, I know trustee Hunter has to drop off. As long as trustee Heck stays on, we'll have a quorum. So I know trustee Swartz is East Coast and it's really late. So I'm sure she's gonna drop off shortly too. But as long as trustee Heck, you stay on, we're gonna have a quorum and can finish the business.
How long do you think?
Yeah.
Yeah.
Okay.
The time is now 9:29 PM and the executive session has been concluded. The participants in the executive session were Administrator Nguyen, Trustee Stelter, Trustee Check, Trustee Mayor Pro Tem Valentine, Trustee Schwartz, Trustee Hunter, Trustee Heck, Clay Buchner, Walsh, same. Josh Mack,
Francisco Colorado from Sursa.
Francisco Sursa, and Corey Heininger. For the record, if any person who participated in the executive session believes that any substantial discussion of any matters not included in the motion to go into executive session occurred during the executive session, or that improper action occurred during the executive session in violation of the open meetings laws, I would ask that you state your concerns for the record. Any concerns from anyone? Okay, hearing none. The next agenda item is.
You need to extend the meeting.
Sorry?
Extend the meeting.
Oh, gosh. Can I have a motion to extend the meeting?
I want to make a motion to extend the meeting for 45 minutes.
I'll second the motion.
All in favor?
Aye.
Okay, hearing no opposed, that motion carries.
Did you ask for opposed?
Oh, I didn't. Anyone opposed? Okay, we are continuing with action item number 2, which is continued from our last meeting, resolution 2024-15, adopting a mission statement and values statement for the town of Paonia, which is on page 184 of the agenda packet. And Administrator Nguyen, if you will.
Yeah, so this started in October. This was part of our SWOT analysis, that workshop that we had. You've seen this mission statement and these value statements before. This is a resolution formally adopting those mission and value statements so that they can go into a strategic plan for the upcoming budget due on December 10th. This is the resolution that adopts it. All of the fun whereases, and then what is the actual exhibit? Exhibit A is mission statement. Paonia is a vibrant community that values our rural small town history and heritage, centered on education, recreation, social and economic diversity, and a government that ensures a quality of life for all residents by striving to provide exemplary service in a safe, healthy, and transparent manner while protecting our precious natural resources. The value statements are all there: resiliency, family and community, conservation, recreation, natural resource, and economic development. And here is the visual that was presented to you before.
Any discussion amongst the trustees? I should back up. I don't know if there's anyone from the public still attending by Zoom. Is there any comment from the public? Seeing none. Anything for the trustees? So would someone like to make a motion?
I move to approve resolution 2024-15, adopting the mission statement and value statements for the town of Paonia with the following edits: attachment A, attachment B, and attachment C.
Second.
All in favor?
Aye.
Opposed? None. Okay.
Thank you.
Thank you. And do we still, we have trustee Schwartz and trustee Heck, correct?
Correct.
Okay.
Trustee Hunter did send a message.
Yeah, I knew I was just making sure we are still holding up. Okay. So let me ask a question, and it has to do with the agenda. Agenda item number 4, consideration of adoption of ordinance enacting electronic communication and device security policy. I have read it, it's quite lengthy. For the sake of time, let me ask Clerk Vetter, does this need to be adopted or considered tonight?
As much as I would like it to be, I think it would be fine to move it to the 10th. I think it definitely needs to I'd like to have it done by the last meeting in December at least, so we can go into the new year with it in place.
Okay.
We got some big changes coming next year, and this is really important that we have, so.
All right, well, we have 1, 2, and I was gonna ask, action item 7 could be continued, but I'll ask that when we get to it. So we have 1, 2, 3, 4, 5 items on the agenda. I don't know, I'm sort of asking, so let's go ahead and go forth with action item number 4, which is adopting that ordinance. Yes, electronic
I thought we
device.
discussed this last time. Didn't we?
We've not discussed to the detail that this is, we talked about requirements for using town email. That was voted on, and this just gets into much more detail of all the electronic policy for everything, for security and everything. I mean, it's a very thorough, important policy. And
Madam,
yes.
I was sorry if I could just toss in there, and I would just as soon you guys wait till the 10th if you haven't had a chance to review it, because one of the reasons we're adopting it is because we specifically are asking you to hold all your boards, committees, and commissions to the same standards that town staff is for electronic communications and device. So
with that, do we have a motion to continue this to the next meeting?
The proper motion for the table it to a December 10th meeting.
I make a motion that we table this electronic device policy until the next meeting.
Second?
I'll second that.
All in favor?
Aye.
Okay, thank you. We do need to make a decision on the RFP for brush clearing for the hydrological study, contractor selection, and Trustee Wynn?
Yes, so the proposal
Mr.
went
Wynn?
out. So the proposal did go out. It was received November 20th. We had 3 respondents. They're in front of you in one of the printed paperwork. I'm sorry I didn't get into the packet. I took Friday off, and they only submitted them to me. So, but we have 3 proposals. They are, the first one is from Diamond S Fencing. Their proposal was for, they're out of Scott City, Kansas. Their proposal was for $41,850. We didn't submit any of the additional required paperwork with it. And they are the highest. The next one is from Gunsight Holdings LLC, doing business as Carroland Works. They're from Basalt. And they did provide all of the documentation that is necessary to be considered as part of this, to be considered for the work. They did provide references, and their total cost was $12,800. The last proposal is from Hemlock Consulting. They were the lowest proposal, but they also have the most experience. They're also board certified master arborists. And they're doing, where are they from? I want to say they're from Leadville. So they're also native to Colorado, and their proposal cost is not that first one, it's going to be the second one, which is $11,763. They also have done work on Forest Service lands and BLM land, of which our proposed brush clearing is on. If I were to say who is the most responsive and responsible, the lowest, most responsive and responsible bidder, it would be Hemlock Consulting. And so that would be my recommendation to move forward with that. And that wording is really important. Lowest, most responsive and responsible bidder.
Why was there 2 price?
That was if they could get it done this year or if they waited till next year. And so we're going with the higher price because there's no way they're going to get it done. There's a lot of snow about it.
Discussion amongst the board?
Responsive bidder.
Any discussion on this? And I don't think we have any public for input. If someone would like to make a motion.
I make a motion that we approve the bid for Hemlock Consulting as the lowest and most responsive and responsible bidder.
Do we have a second?
Second.
All in favor?
Aye.
Thank you. This also gets us under contract with our Water Smart grant. So it was the necessary last step. So thank you.
Great, thank you very much. And the next item is one I can describe. So it turns out at our planning commission meeting, the one before this last one, it was whenever it was, 2 times ago, Calla Rose Ostrander was in the audience, and there was much discussion of how can we make sure that the final draft that we want public input on, how can we get the best information out to the public to get them in attendance and to have them ask, make comments, etc. And Calla Rose said that she offered to use the last $394 in the Phoenix Rising contract to help with that outreach. The Planning Commission thought that was a great idea. There was a lot of discussion about things she could do to help the Planning Commission. And so, so the Planning Commission is asking the trustees to approve the remaining budget in the Phoenix Rising contract to be used to help work on the meeting that will be held for this. Actually, it's going to be a workshop for the public to come to, and it is yet to be determined. It will not happen in 2024. We're looking at possibly having that workshop sometime in January, because, yes.
Can I boil it down really simple? So the request is to allow the Planning Commission to use the remaining balance for Phoenix Rising Resources to do the public outreach for the final draft of the comprehensive plan.
And it will be a draft it will not be the hearing that she's doing. This is the workshop. So the public will have opportunity to come in and have a back and forth discussion. Any comments? And would someone like to make a motion on page 255?
I make a motion to approve the remaining funds in the Phoenix Rising Resources contract to be used to provide assistance to the Planning Commission with public outreach regarding a yet-to-be-scheduled workshop to be held in consideration of all changes made to the draft comprehensive plan since June 21st draft was published.
I'll second it.
All in favor?
Aye.
Thank you.
They roosted.
And so action item number 7, we'd like to continue that, table it and continue it to a meeting in January, simply because, or was it?
February 11th.
Oh, until February 11th, when there is more time for discussion of this new approach.
Oh, I'm sorry, the Citizens Watch Group, you're right, Jenny, I'm sorry.
Oh, January, the first meeting in January?
Yes.
And where Stefan can explain what this is. If folks are okay with tabling and continuing, a motion to that effect would be wonderful.
I motion to table this resolution until January?
January. The first meeting.
First meeting in January.
We have a second.
Second.
All in favor?
Aye.
Okay. Now, action might approve a resolution opting out of certain elected and appointment positions from workers' comp. This is something we have to do every year.
SRSA requires it, so it's Resolution 16/2024 requires that we do a resolution opting out of paying for workers' compensation for uncompensated board members and
trustee.
Yeah, and you.
I don't see the tree board on this. Should they also be included in section 1? We're listed Board of Trustees and/or B, Planning Commission and the Zoning Board of Adjustments and Appeals. Does the tree board, they're also a codified board.
256.
Yes, and so if you do approve this resolution, you would say as amended to include the tree board.
Any discussion? Did he make a motion?
I make a motion that we approve resolution number 16-2024 as amended.
I second.
That flew by me. I didn't know.
All in favor?
Aye.
Any opposed? Okay, all right. Last action item number 9, discussion on the capital improvement phase 1 project needs assessment. It begins on page 258. Turn it over to you, Administrator Wynn.
We're almost done. So this is capital improvement phase 1 for the water improvement plan. We do have a public meeting scheduled for December 11th. That's when our engineers will be here. We're planning to invite the water companies as well, because this is specifically to talk about not just those improvements like the $2 million water tank lining, but most importantly, the Western Loop water main replacement project. Something that you recently approved an EIAF grant to go out for $1 million for. It's going to be a $7.2 million project, that one alone. It replaces and realigns the existing pipe out of the majority of it being in private right-of-ways into public right-of-ways following the road system. But this is, we need your approval to have this meeting, which is the last step in applying for funding come January for that low-interest drinking water revolving fund. Oh, Mike is coming back in, sorry. Trustee Heck is coming back in.
Oh, yes.
I just have one question on page 278. On line number 32, it has easement negotiations, and of that, it's $239,936.
We don't really want that public because that's the money that would be available to purchase right-of-way if we needed to through some of the private easements that we can't get out of. So we still have to go through some private easements. And then it would also cover the cost of application fees to the county. I will try my absolute level best to get them to waive the fees, but I doubt I'll get that accomplished. And so I'll still have to do some application fees for that. So.
Any other questions from the trustees?
I just have a question about the total project cost. I know there's a 20% contingency built in there. Given that this quote was done a year ago, do we still think that this total project cost is accurate?
No. So I don't know how this part got in here. I didn't add it to the agenda packet. It's this specific one for the 8-inch steel distribution line replacement is $7.2 million, $7,200,000. But this isn't the public hearing. This is the discussion to have that public hearing on December 11th.
And do you expect to have different content?
Yeah, I don't know. I don't know how this made it in. So
would all the attachments be attached?
Oh, absolutely. In that actual agenda packet, that it would be
for the meeting. Okay,
Yes.
because they're not in here.
Yeah.
Any other discussion? Somebody like to make a motion to essentially
Meeting.
Yeah.
Approve having a meeting on December 11th.
I make a motion that we approve the meeting for December 11th for the final meeting with respect.
It'll be for
for phase 1 of the project needs assessment.
I'll second that.
That's fair enough. That's exactly what we're doing.
All in favor?
Aye.
Opposed? I didn't hear Mike.
Aye.
Okay,
My
thank
computer
you.
was off for a minute, so I missed
That's all right.
half of it. That was a
Okay.
listening eye.
I just wanted to make sure we got everybody in. And on that note, I have no report. I don't have any trustee reports. So we have completed our agenda. And I would like to adjourn this meeting.
Thank you all.
Have a happy Thanksgiving,
Thank you
guys.
for everybody hanging in there on the East Coast.
Good evening, guys.
Good night.